welcome back to my channel Legal Knowledge. In this video, we are going to learn about patent under intellectual property rights. So this is the first part of this video. In this video, we are going to cover meaning, patentable invention and non-patentable invention and how to obtain patent. Under this, we are going to see who may apply and procedure for filing an application. So without wasting any more time, let's begin our video, and also don't skip the video to understand the chapter completely. So let's start. Meaning of patent. A patent, which means an exclusive right granted to a person who has invented a new and useful article or an improvement of an existing article or a new process of making an article. Which means a patent is a right given to a person who has created something new and useful article that are not previously existing in any of the places. Or if a person made some advancement or improvement in existing article, then the person can apply for a patent and he is eligible to get a patent right. And that person is called as a patentee. The patent is limited for a period of 20 years from the date of filling of the application, and after the expiry of that period, any person can make use of that invention unless the patentee renew it for time to time. Then the patent is territorial rights. If a person got patent in a country and that patent is not valid in any other countries unless he got patent from other countries. The mere idea or principle cannot be patented. The invention should be in a materialized form. The main motto of this patent law is to encourage the investors to concentrate more on their field by awarding them this exclusive right to secure their invention. Now let's see an example. I made this pen which is completely new and nobody have any idea about this product or an item. So in this case, I can get patent for this item pen. If suppose another person B made similar product and asking for patent means he is not eligible to get patent because I made it previously and I got patent for this item. So he is not eligible to get patent for that item. If suppose he made some advancement or improvement in this item by fixing laser light in the top which is useful for presentations. So in that case, the person B is eligible to get patent because there is an advancement, there is an improvement in that item. So he is eligible to get patent for his item. So now we understand the meaning of patent. Next we see what are the things that can be patentable. The first thing is novelty. Section 2 clause 1 of Patent Act 1970 says new invention, which means invention must be completely new and no person should have any idea about that invention, or no information or principle should be published in any of the public domain in any world. The second thing is inventiveness. Section 2JA of the Act says inventive steps, which means there should be some invention or advancement. If a person claiming a patent for existing item, then there must be some advancement or improvement in that previous item. The third thing is capable of industrial application. The invention must be have practical usage and it should be applied in industrial any industries. Next we see the inventions that cannot be patentable. The first thing is invention that are frivolous. The invention that are considered useless, valueless, senseless, simply waste of time. The second thing is against public morality and order. Invention against the norms. Example, counterfeiting of currency note, which is against law and it is punishable act. Also any material that is helpful in robbery or theft, which is against public morality and order. And the third thing is mere discovery of scientific principle that already exist in nature. For example, discovering some micro-organism that already existing in thousands and hundreds. And the fourth thing is mere discovery of new from known substance. Making some minor change in a substance that already known and with the same usage cannot be patentable. And the fifth thing is mere admixture. creating something new by adding one or more products items that already known in nature cannot be patentable. That is considered as aggregation. And the sixth thing is mere aggregation or a duplication of devices. Discovering something by rearranging the devices that already existing and that have the capacity to function independently. And the seventh thing is a method of horticulture or agriculture. Improving the method of improving the soil texture cannot that cannot be patentable. And the eighth thing is a process of medical methods, like surgical methods, treatments, that new treatments that cannot be patentable. And the ninth one is mathematical or computer programs. Any maths formulas or calculations or any computer programs that cannot be patentable. And aesthetic creation, which means writings, paintings, artworks and musics that cannot be patentable. And the 11th thing is plants and animals. Discovering new seeds or new species that cannot be patentable because it's a product of the nature. And atomic energy, like human bombs, guns, that cannot be patentable. And the presentation of information, project presentation, like that cannot be patentable. And the 14th one is a rule or method of performing mental act or game, like chess and Sudoku games that are invention rather than that is used for mental improvement, like mind exercises, so that cannot be patentable. Next we see how to obtain a patent. Under this, first we see who may apply. Section 6 of the Patent Act 1970s defines this. The first one is first investor. The person who created the idea, the person who made the invention or the principle is said to be a first investor. And second one is assignee. The person representing on behalf of the first investor or in respect of the first investor to make such application is said to be assignee. The third one is legal representative. If a first investor is deceased or dead, then a legal representative can apply such application. If then invention made by an employee. Suppose if invention is made by an employee under a certain agreement, then the patent for that invention is made under the name of the employee and the patent belongs to that employee. Next we see the procedure for filing a patent application. Section 7 of the Act deals with the form of application required. According to this section, an application should be filed in the patent office with the prescribed form. Number 1 is it should state that applicant has a possession of the invention that he made, and that is the first inventor. And the second thing, it should contain a complete specification about the invention, and that specification should be submitted after 12 months from the date of submitting the patent application. The specification should contain a brief note about the invention and a description about the invention in a detailed manner, and it should mention about the usage and the motive of the invention, and it should also contain the technical information about the invention in that specification. And the third thing is third process is the application of patent will be published in a public platform only after 18 months from the date of submitting the patent application. Then the examiner will then the applicant will send it to the examiner to check whether there is any legal grounds for objection to grant a patent, and also will check whether the patent has already been published or declined by any other person. Then the fourth process, after such examination, the officer will communicate with the applicant about the objection that is made that has founded previously, and the applicant should remove those objection from his invention. After removing those objection, then the invention will be published in official gazette. The fifth process is if any person has any opposition for granting patent, he has to notice within 3 months from the date of publishing in official gazette. Then remaining part of the video will be covered in second part. Thank you for watching my video. We will meet in next video.